According to law, adultery and extramarital affair of a wife is a crucial factor while deciding on interim maintenance. However, the grant or refusal of maintenance to a woman living in adultery is very subjective and dependent on how a particular judge views the same. In a recent order passed on October 16, 2024 by the Allahabad High Court, a single bench of Justice Manjeev Shukla emphasized that the court under Section 125 of the CRPC has to decide the issue of alleged adultery against the wife before awarding her interim maintenance. So what was this case all about? In April 2023, a family court in Uttar Pradesh had passed an order of interim maintenance granting Rs 7,000 per month in favor of the wife under Section 125 CRPC. Now, the husband in the matter had challenged this impugned order, accusing that his wife was living in adultery and thus she was not entitled to receive such kind of interim maintenance. The Allahabad High Court went through the arguments from both the sides and held that if there was a categorical allegation of adultery against the wife, then the court, that is the family court, is duty bound to first decide the issue of alleged adultery against the wife and then proceed whether she is eligible for grant of interim maintenance under 125 CRPC or not. Now let us understand what were the submissions made by the husband when he appealed the family court order in the High Court. Advocate Rishabh Agarwal, who appeared for the husband, he challenged the family court order in the proceedings, which were under 125 CRPC, where he stated that the husband had categorically filed a reply mentioning that his wife was living in adultery. And therefore, if we look at the provisions which are contained under Section 125, subsection 4 CRPC, she was not entitled to receive either interim or final maintenance. The husband also went ahead and defined the subsection 4 under Section 125 of the CRPC, which reads as follows: no wife shall be entitled to receive an allowance for the maintenance or interim maintenance and expenses of proceeding, as the case may be, from her husband under this section if she is living in adultery or if without any sufficient reason she refused to live with the husband or if they are living separately by mutual consent. Now let us understand what were the observations of the Allahabad High Court. A single bench of Justice Manjeev Shukla prima facie found that the exercise that was required under Section 125(4) CRPC was completely missing in the matter, and without recording any finding on the issue of adultery, the impugned family court order dated 13th April 2023 had been passed awarding interim maintenance to the wife. Justice Shukla also went ahead and observed that once there was a categorical allegation made by the husband with regards to adultery by wife, then the concerned court dealing with such a matter under Section 125 of the CRPC must first decide the issue of adultery, and interim maintenance can be subsequently awarded only after recording a finding on that issue. The Allahabad High Court accordingly stayed the impugned family court order and issued a notice to the wife to file her counter affidavit against the allegations leveled by her estranged husband. Now, what is Voice for Men India take on this? Adultery as an offence was decriminalised by Supreme Court of India in the year 2018. However, adultery still remains a civil ground for seeking divorce. To prove adultery is an extremely tricky task for the husband, since most form of evidences that he brings forward could be rejected by the court, citing breach of privacy for his wife. While subsection 4 of the 125 CRPC deals with adultery as a ground to reject lifelong maintenance to a separated wife, the outcome of such cases are largely dependent on the interpretation of individual judges. Let me quote some examples. In April 2022, the Delhi High Court had ruled that occasional adultery or isolated acts of adultery by a wife does not disentitle her from receiving maintenance from her husband. In October 22, the Punjab and Haryana High Court had also defined that living in adultery means continuous adulterous conduct and not a single or occasional lapse. While in the same month, the Punjab and Haryana High Court in another case had refused to grant permanent alimony to a woman who was divorced by her husband on grounds of adultery. And then in December 2021, the Delhi High Court had passed a conflicting order stating that the issue of adultery should be decided only at a later stage and not during the grant of interim maintenance. Having quoted these examples, I feel the current October 2024 Allahabad High Court order is very much relevant and can be used by all men who are facing similar situations where the family courts are not entertaining their allegations of adultery or not deciding on the allegations of adultery before passing interim maintenance orders. If we observe, many of our laws on paper seem to be just. However, over the years, the application of these laws favoring only the wives have distorted the rightful means of justice for a man seeking divorce. I'm leaving this entire Allahabad High Court order in the description link of this video. Do check out and use the same if it benefits you. You can keep following us on our social media handles, that is Facebook, Instagram, X, Telegram. The ID is @voiceformenin. You can also subscribe to our YouTube channel, that's Voice for Men India, for many such videos, interviews that could be relevant and helpful to you. And you can read all the orders, judgments, different stories and cases on our website, www.voiceformenindia.com. That's it from me as of now on this case. Thank you very much for watching. Namaste. Jai Hind.